on this floor outside? No, he does. You don't have to do nothing. Yeah, I'm not requiring you to do a thing except for ride her, which I've got a feeling you're going to do anyway.
Right outside the courthouse.
This is Mr. Thomas.
And they'll help them out.
State your name, sir.
And then,
Oh. John
14.
Doe. Book him in as everything. Oh. Mr. Kramer, how you doing? I know.
Yes, sir.
Garrison? Okay. Mr. Kramer, you're fully court charged of battery on a law enforcement officer and resisting officer without violence. Can you understand those charges? This isn't going to go well for you. All right. Boogie board on over. Bond set at $15,000 on the battery on law enforcement officer, $5,000 resisting. Court date's going to be July the 17th at 9 o'clock with pretrial release.
All right, you can step to your right for your copies. Next.
Let's roll, nerds.
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am.
All right. Okay. All right. And there's also an enhancement paragraph. Are you proceeding on the enhancement in each count?
So just regarding count one, regarding count two.
Okay. I understand. All right. All right. Mr. Jimenez, did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? In count one, you're charged with aggravated robbery. If the state is able to prove up the enhancement allegation, your range of punishment is anywhere from 15 years to 99 years or life, and a possible fine up to $10,000. In count two, you're charged with unlawfully carrying a weapon with a felony conviction. According to the plea bargain agreement, punishment is to be assessed at 15 years in count one, and in count two, they're not. That is, you're right. Okay. So according to the plea bargain agreement, you're to be sentenced to 15 years in count one. In count two, you're to be sentenced to 10 years. Counts one and counts two will run concurrently. Is there anything, because I'm trying to do it from memory at my first glance of the paperwork. All right, and there's a $2,000 fine. Did you understand that to be your plea? Defense is at the plea.
It is, Your Honor.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest? To the enhancement under count one, how do you plead? True or not true?
True.
To count two, how do you plead? Guilty, not guilty, or no contest? State any evidence.
The offer states one attachment.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and consent to stipulations of testimony with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty of counts 1 and counts 2. The court will find you guilty of counts 1 and counts 2. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you waiving PSI?
Yes, Your Honor.
All right. In count 1, the court will sentence you to 15 years in the prison. Give you credit for any time served. The court will sentence you to 10 years in count 2. Give you credit for any time served. In count 1, there's an affirmative finding of deadly weapon. Counts 1 and counts 2 will run concurrently. There's a $2,000 fine. Is there anything else with regards to sentencing?
Yes, Your Honor. He had a federal case that he got 17 months on. It's still, he entered custody on May 12th, 2022, which is 3 weeks after this case. And he's been in continuous custody since. I believe he was released from Karnes County, which is the federal penitentiary, where they're holding him actually on September 24th, 2024. But he has been in continuous custody since May 12th, 2022 to present.
Oh, he'll receive credit for that time.
Thank you.
All right, did you speak to an attorney? Do you understand? All right, we can go off the record. So here's my question. Why the tears?
I'm signing my life away.
Well, I mean, this is your choices. I mean, this is over you taking some beer with a gun in your hand. Was a beer worth 15 years of your life? Well, that the stipulations that you agreed to, I've read it, and you put somebody's life in fear of their life because you wanted what they had. So what I can tell you is, if you want to cry, cry for the person that you put their life in danger when they're just trying to do their job. If people don't want to go to prison, people shouldn't do prison things. Well, I mean, you had a chance to be in the free world, to be with your children and your wife, but you chose this. So this is where we are. If you would have gone to a jury trial and a jury would have found you guilty, let me just tell you, based on my experience, you know what a jury would have done? They would have looked at your tattoos. They would have known what those tattoos meant because they would have been told what those tattoos meant during punishment, and they would have gave you life, and they would have went on their way. They would have gave you life on that case, and for the gun case, they would have given you the maximum. So if you don't want to be standing before a judge crying about your wife and children, then stop doing this. All right, good luck to you. Oh, thank you.
Thank you, Your Honor.